I'd like to give you what I think are the 5 compliance takeaways for this year. 5 things that I think compliance officers and companies will find most interesting. My number 1 is that whistleblowers are likely going to be a factor, increasing factor in FCPA enforcement. The whistleblower program became effective in August 2012. It allows individuals who voluntarily provide the Securities and Exchange Commission with original information the possibility to receive between 10 and 30% of all monetary penalties exceeding $1 million. Now, we know from 2012 that only a small portion of the whistleblowers have raised FCPA allegations, but there's every reason to think that that percentage is increasing. Companies that have compliance programs that have really been based upon hotlines have to worry about whistleblowers now. Plaintiffs' bar and plaintiffs' law firms have set up groups to begin to attract whistleblowers with the idea of sharing the monetary proceeds from any return from an SEC award. According to the SEC Chief of Enforcement, there's an increasing sophistication in the level of detail in whistleblower tips, and the SEC appears to be willing to approve substantial whistleblower awards, providing incentives to whistleblowers and the plaintiffs' bar alike. Just on October 1 of this past year, the SEC announced the largest award to date, more than $14 million given to one whistleblower for information that they provided to the federal government. The whistleblower program will provide incredibly impactful cases, according to the Associate Director of the SEC's Division of Enforcement. So for me, the first takeaway is whistleblowers are important and attention needs to be paid to them. The second topic I'd like to discuss involves U.S. regulators continuing to expand the extraterritoriality of the FCPA. Regulators seem intent on prosecuting cases where only the most tenuous connection exists with the United States. In the Total case, a case from this past May of this past year, French oil company allegedly used 2 intermediaries to fund $60 million to an Iranian official in return for contracts. The combined settlement from all the parties of nearly $400 million was the 4th largest in FCPA history. Yet the U.S. nexus was somewhat tenuous. ADRs traded by the company, $50,000 sent by wire from New York to Switzerland, hardly any conduct at all, if any, in the United States, yet an extraordinarily high award. Another case that falls into that category is the Ralph Lauren case from April of this past year. In that instance, the general manager of Ralph Lauren's wholly owned Argentine subsidiary allegedly approved a customs broker's payment of $568,000 to Argentine customs officials. Yet the U.S. nexus was very slight. The DOJ and the SEC characterized the general manager of the Ralph Lauren Argentina subsidiary as an agent of Ralph Lauren Corporation. But there was really no conduct in the U.S., yet prosecutors brought the case. Again, the Philips case brought in April of 2013 is another case involving Philips, its healthcare company. In that instance, a Polish subsidiary made improper payments allegedly to officials at a Polish healthcare facility. Again, no real conduct in the U.S. Yet, in that instance, the books and records provisions and internal controls don't require a nexus between the conduct and the U.S. And so that case was again brought. So again, extraterritorial reach of the FCPA continues to grow. My third topic is somewhat more uplifting. Internal controls, investigations, cooperation with regulators, and remediation continue to mitigate enforcement risk. In fact, they can prevent prosecution altogether. In the 3M case from February of this past year, 3M was apparently involved in some issues involving its Turkish subsidiary. Yet cooperation, remediation, and internal investigation were all cited as part of the Department of Justice's resolution of the case. 3M's voluntary disclosure and enhanced compliance program were all reasons cited for the Department of Justice closing its investigation. The Parker Drilling case from April of 2013, where Parker Drilling allegedly made a payment to a third-party Nigerian agent to use that agent's influence to settle a customs dispute, ended in a positive resolution for Parker Drilling based upon cooperation and remediation. Parker had widespread corrective action, ending relationships with the various parties, enhanced scrutiny of its agents and its contracts, and enhanced system of internal controls. They received a 20% reduction off the bottom of the fine range. Again, a very significant benefit for cooperation. The Ralph Lauren case, which we've already mentioned, an issue again discovering payments in a foreign subsidiary, resulted in a punishment that was mitigated significantly by Ralph Lauren's substantial cooperation and the remediation of the wrongdoing. A non-prosecution agreement was stated shows the benefit of implementing an effective compliance program. And Ralph Lauren benefited a great deal from its effective compliance program and its remediation. But with this, still, the Foreign Corrupt Practices Act remains a top government priority, a significant area of resources being expended to go after this type of wrongdoing, and lots and lots and lots of investigations. 2012 saw a marked decrease in FCPA enforcement, but 2013 has rebounded significantly. By pure numbers, 2012 enforcement activity dropped by 50% when measured against 2011. Prosecutions against companies dropped by 30%, and prosecutions against individuals dropped by 70%. However, the enforcement activity in 2013 demonstrates that 2012 was an outlier, not a trend. If the year were to end today, in November of 2013, overall enforcement activity would have already increased by 40%. 2013 enforcement activity also demonstrates a very significant takeaway. Individuals are now at risk more than ever before. So far, the Department of Justice has prosecuted 3 times the number of individuals in 2013 as it did in 2012. The Department of Justice has demonstrated a willingness to pursue traditional enforcement techniques when pursuing individuals. Informants, as they used in the BizJet case, 2 of whom worked undercover or otherwise provided information to the government. In a case involving investigation in Guinea, the FBI worked with the widow of a former Guinean president to secretly record meetings in connection with that bribery investigation. On April 16, 2013, the Department of Justice announced criminal charges against several individuals from Alstom Power relating to bribing Indonesian officials to obtain a $118 million contract. So one of the big takeaways is individuals remain at risk more than ever before. And finally, my last compliance takeaway of this year involves significant and focused attention by regulators on liability for the acts of joint ventures and joint venture partners. This is new because nowhere in the statute do we see a mention of joint ventures, yet the Department of Justice and the SEC, in their resource guide, describe an issuer's responsibility and that responsibility extends to joint ventures. A U.S. company can be held liable under the FCPA for acts of its purely foreign joint ventures or teaming partners. The guidance that the DOJ and the SEC put forth used various case studies as examples, including 2 Chinese joint ventures where a partner company paid over $400,000 in bribes to obtain business, even though these payments were made exclusively in China by Chinese employees of the Chinese joint venture. But the U.S. company failed to have internal controls to monitor the JV, failed to train the JV, and failed to effectively impose its compliance program on the joint venture. So the takeaway there is, under the Foreign Corrupt Practices Act, the accounting provisions, and if you have members on a board of a joint venture, you have to use reasonable efforts to maintain a proper system of internal controls at your joint venture. If you own more than 50%, this means that you must devise and literally impose upon the joint venture a proper compliance system and proper internal controls. If you own less than 50% of a joint venture, the law tells us we have to proceed in good faith to do the best it can. But as a practical matter, if you're a major company with people on the board, with capital commitments, with funding requirements, and giving technology to that joint venture, nobody's going to view you, at least the government won't view you, as a passive joint venture partner. So, with regard to joint ventures, the buzzword for 2013 is focus on them, keep them in sight, and make sure they have a proper compliance program, or else you will be responsible for any of their wrongdoing. So those are my 5 compliance takeaways for the year 2013.